Hello folks, welcome back to the Edupedia world, and I am Abhinay Gupta. So today again we'll continue with the topic, the Competition Act 2002. Right? So far we have covered a major chunk of the chapter. Right? We have seen the various definitions that are important for you. We have seen the various important sections that have been referred by the institute either in the question papers or in the practice manual or in the revision test papers. Right? So there are just two more sections that we are yet left to cover from where questions have been asked in your past examinations. And once we are done with that, we are done with the important parts of the Competition Act. The other sections that are available for you in the syllabus and in the study material, if you refer to them, they have never been tested by the institute. They are not so important, and hence they are not even referred by the institute in the practice manual itself. And over the past all the years after 2002, since the Competition Act has been established, there has never been any question from those sections. Right? So, now the other two sections that are remaining is section 19 and section 5, the combination. So today we'll deal with section 19, the inquiry into certain agreements and dominant position of enterprise. With the name, is there something that you can relate to, that you can reflect to, that we have already covered in the previous classes? Any one of you? Just think about it. We are talking about certain agreements. So basically, if we are setting up an inquiry, right, and that too under some agreements, then what are the kinds of agreement for which we need to set up an inquiry, for which an inquiry needs to be conducted? If you give it a simple thought, you would know that yes, we are talking about the anti-competitive agreements. That means we are referring to section 3. Right? So if there are any anti-competitive agreement entered into by any enterprise or group of enterprise or whatever we have seen over there, the cartel and everything, so if there is something like that that exists, then an inquiry has to be made into the situation. Right? The second part of the heading is the dominant position of the enterprise. Now, why do we ever need to inquire the dominant position? It is good if somebody is having a dominant position. What's the problem? The problem is if they are abusing it. So now we would refer to section 4. So if there is any entity, any enterprise that has a dominant position in the market and they are abusing their dominant position, then an inquiry has to be set for that too. Right? So when we are talking about inquiry, who is the authority that is required to make this inquiry? I don't think you need any option for that. It is straightforward, the commission. We have seen that commission is the body with authority in this act. Right? So the commission would make an inquiry into the agreements or the abuse of dominant position. So the commission would inquire the contravention of provisions of section 3 and section 4. Now, when would the inquiry do so? Why would it do so? All fine day, one fine night, will it have a dream that okay, something like that is happening? No. They will get the information. Right? So what are the basic sources of information to them? What are the basic conditions on which the inquiry is based? When would they set up an inquiry? The first thing is they would set up an inquiry that is suo motu, on their own motion. Right? Now, if we are talking about an inquiry on their own motion, again, is it a random thought coming to their mind? No. They would gain some information. Right? So if the commission becomes aware of any certain adverse effect in the market, right, in the economy, then it would set up an inquiry as to see what are the effects of that agreement, or whether or not it is an anti-competitive agreement, and whether or not the dominant enterprise is abusing its position. Right? That is when it comes to know that yes, something is going wrong in the market, and then it could all by itself start an inquiry. Otherwise, if it receives any information from any consumer, which means the consumers are allowed to make a reference to the commission. right? But that could lead to a situation where anybody at any point of time could just rise up and make an attempt to make an inquiry. They would just come and give an information, okay, this company is doing this, please set up an inquiry. So that can be possible, right? Anybody can randomly come up, and unless and until they hold the inquiry, they will not be aware whether the consumer is right or wrong, right? So for that purpose, what they have done is they have allotted certain fees for this information. So if you want to send an information, and if you want the commission to make an inquiry for the adverse effect in the market, you will have to accompany your information along with certain fees that is prescribed, right? Basically, who would come up to give that information? The competitors, the people who are being affected by the dominant position, they would come up, right? So if they want their position back into the market, or if they want a fair play in the market, they would be ready to spend. That is the purpose of fees behind it, right? And third is on a reference received from the central government or the state government, right? So if the commission at any point of time, or if the central government or the state government at any point of time feels that no, in their country or in their state there is certain company that is operating with an adverse effect in the market, or there is a certain group, there is a cartel prepared, or there are enterprises entering into agreement that is affecting the market, either controlling the production or they are inflating the price, or whatever they are doing, ultimately the consumer is suffering, right? So if these three situations are prevalent, they could make an inquiry into the matter. Clear with the point so far, right? Now when they are setting up an inquiry, what is it that they want to get out of it? What would they inquire? That is a question that should come to your mind. What is it that they are inquiring? Right? So basically, they are setting up an inquiry to determine three specific things. Right? So what are they? Number one is the appreciable adverse effect on the competition. So this would relate to section 3. So section 19 subsection 3 relates to determination of the appreciable adverse effect on the competition due to the formation of the anti-competitive agreement. Right? Now when they set up an inquiry, what are the effects that they would consider to be adverse? How would they understand that yes, these effects are adverse effects on the economy? What would they check? Right? So they would basically see if there is any barrier that is created for any new entrant into the same competition. For example, X, Y, Z are only three companies in the market for distributing any specific product, and now there is company 4 that wants to come up, right? And they have entered an agreement with all the distributors, right? What is the agreement? The exclusive supply agreement, that we would be your exclusive supplier. So if they are the exclusive supplier, obviously the fourth company can never penetrate into the market, right? So these kinds of agreements would have an adverse effect. So the commission is basically needed to see if there is creation of any barrier on the new entrant. This is a complete barrier, right? Then they would see if there is any situation that is compelling the existing competitors to leave the market. So first of all, there is an obstruction on the barrier, and second, all those who are still in the market, who have already entered the market, they need to be chased out. So if there is something that is compelling them to move out of the market, right? If you have entered into an agreement that helps or that supports their movement out of the market, then we would consider that agreement to be an anti-competitive agreement, and as per our inquiry, that is having an adverse effect on the market, right? Apart from that, if for example they have not set up a complete barrier but still they are hindering the entry into the market, then also we would consider it to be an adversely effective anti-competitive agreement, right? Then are these the only three, the inflow and outflow of the competitors? No. When we are talking about the adverse effect, our basic concern is the consumer, right? So we will see if there is anything that is hindering the accrual of benefit to the consumers, right? If there is some situation like that, we would consider it to be an anti-competitive agreement having adverse effect. otherwise also if there is something that is hindering the improvement in the production or the distribution. That means if the companies have entered into an agreement that we would restrict the supply in the market, so for that they are restricting the production. Okay, this year we would produce just half the quantity. We want to create an artificial scarcity in the market, due to which the demand remaining constant, our price would inflate. So that kind of an action would not be entertained, right? And the last point is that if they are hindering the promotion of the technical, scientific or economic development by means of production or distribution of goods or provision of service, right? So there are basically 6 aspects or 6 type of effects that we would consider to be an adverse effect, appreciable adverse effect to be very specific, right? First, obstructing the inflow of the competitors. Second, forcing the outflow of the competitors. Third, hindering the inflow of the competitors. Fourth, not allowing an accrual of benefit to the consumers, not allowing the improvement in the production or distribution, and not allowing the promotion of the technical, scientific and the economical development. Right? Now you're clear with it, what are the adverse effects? So basically the adverse effect is wrapped up in the context of the competitors, the consumers, the production and the technical know-how developments, right? Okay, so that is one thing that the inquiry would determine. What is the second thing that the inquiry would determine? The inquiry would determine whether the enterprise is actually enjoying a dominant position. So section 19 subsection 3 was basically an inquiry that would check section 3. Right? So if you have at any point of time not contravened the provisions of section 3, then that would be checked in section 19 subsection 3. Right? And if you are abusing a dominant position, that means if we are supposed to check the deeds of section 4, right, and we have an inquiry to check whether section 4 has been contravened or not, then those checking would be done in section 19 subsection 4. Right? Now how would you determine whether an enterprise is enjoying dominant position? What are the key things? So first of all, you would see its market share, right? Then you would see how much is the consumer dependent on them and the advantages that it enjoys, right? So if we go on into further detail and point to point what are the various conditions that we would check to judge whether an enterprise is enjoying the dominant position. Then first of all, we would check the market share of the enterprise. How much is it? If it is close to 30-40 something, they are not enjoying the dominant position, but if it is close to 80-90, they are enjoying the dominant position. Right? Then we would check the size and the resource of the enterprise. How big is the enterprise? So if it is holding 80% share of the market, it has to be a big enterprise, right? And what are its resources? It must have more resources than any other competitor in the market, first of all, right? The resources should be in continuous supply for them, and the resources should be abundantly available for them. If these conditions are there, that means they are a dominant company, right? Then okay, this is one thing we see. Okay, the company is big, but what if all the competitors are also big, same size, equivalent size? Then would we consider this company to be a dominant company? No, right? So even the size and the importance of the competitors are to be checked. They'll have to be low, they'll have to be small. That is when we'll consider this one to be the only dominant company, right? Now, forgetting about the market, we also know that if the company, the dominant company, it would have the economy power, right? Because they are working on the economies of scale, they have advantages over their competitors, right? They are the market players, right? Then we would also see the vertical integration. That means if they have tied up with their suppliers or to their distributors, that they are fixed suppliers and fixed distributors. That means it is difficult for the competitors to compete. They don't have suppliers for themselves. How do they gain the products to distribute? Right? Or they don't have distributors in the market because all the distributors have been taken away by the dominant company. So if something like that is happening, that it has integration with the major suppliers and distributors in the market, then we would consider this company to be a dominant company. Right? Now, what are the other impacts? This is the impact on the market size of the enterprise and the size and the power of the enterprise. Now, if we move ahead of that, right, then we would look from the point of view of the consumer as well. Right? So if the consumer is dependent on this enterprise, then that enterprise has to be an important one. Dependency means that if this enterprise at any point of time moves out of the market, the consumer is going to suffer. The consumer is not getting its resources because it does not go to the competitors. The competitors are insignificant for them. If competitors are insignificant, that means this company is a dominant company. Right? Then we'd also see the monopoly or the dominant position, which is being acquired because of the political links. Now, when I talk about political links, I'm not talking about the unfair means, right? Which means that they have acquired the dominant position by virtue of certain statute, right? Either they are a government company or they are PSUs, right? Or something like that. That means the statute that is governing them, they have given them the power. They have the backup from the government. So they have to be the dominant company. Right? Now, for example, if we consider SAIL, Steel Authority of India Limited, they are the major suppliers of steel in the country. NTC, fabric, NHPC, the power, the electricity, right? Indian Oil. So these are the companies that have the dominant position because they are either PSUs or government companies, right? They would also check the entry barriers, right? And the entry barriers would include the barriers such as that regulatory barriers, financial risk, high capital cost of entry, market entry barriers, technical entry barriers, economy of scale, high cost of. So if these kinds of effects, these kinds of factors, right, that are impacting the other competitors, but the company under consideration is enjoying, right, that means those barriers are not sufficient for them. They have created barriers for the rest. They haven't created barrier for themselves, but it is for the rest. They are enjoying the economic power. They are enjoying the financial power. Since they have 80% share in the market, they are enjoying the economy of scale, right? So these things have to be considered, right? So for dominance, we would also see their market structure, market size, their social obligation, social cost, the countervailing buying power. What is countervailing? The corresponding, right? The corresponding buying power in the market, right? If they have it, if they're enjoying it. So these are basically the conditions that would prove its dominant position in the market, right? And at last, obviously, the other factor that the commission may deem fit. And now, my dear friends, you have been asked a question on this particular topic in your examinations already, whether an enterprise enjoys dominant position, right? Since it is a very small question, I'm not discussing it separately, but I'm discussing it along with the topic, right? Because again, discussing it separately would take time and discussing the question and then the answer, and hence we have not written the answer. We have not written the question. So listen to it very carefully. It is a very simple question, that is why I have not written it. I will narrate it and you will understand it, right? So the first line, which is irrelevant, I would just read it out. Don't focus on that. It is, the Competition Commission of India has received a complaint that Messrs XYZ company has been abusing its dominant position in the food processing industry. The first is, they have received complaints, right? So they are allowed to get into the inquiry, right? We have seen the second position when they get the information from the consumer. So the first line only says that they have received complaint, right? But then what are you required? The question says, explain briefly the factors that will be considered by the commission to ascertain whether this company enjoys dominant position in the market. So first of all, they have told you that yes, the inquiry can be set up because you have the information from the consumer. Now all you need to do is you need to briefly describe the factors that they will consider under section 19 subsection 4 that we have just discussed, right? So if you actually flip through your study material or the books that you are following, right, you will find it difficult to memorize the entire point, right? So what you do is you need to break it down into segments. So first is the market share, the competitors, the consumers, right? And then the monopoly power, the government backup, and the social obligations. If you remember these 6 keywords, you are good to go, right? So just always remember these 6 keywords and then go through the text, and you will see that yes, you are able to grab what is given and memorize and remember what is given, right? The next thing that it will determine is the relevant market. What is the relevant market? And that is section 19 subsection 5. Now remember, in the first class that we had held for this Competition Act 2002, in the first class we have discussed the various definitions. I hope you remember it. You remember the definitions that we have discussed. So in that definition, we had discussed 5 very important definitions that covered up the enterprise, the consumers and everything, right? And apart from that, we had discussed 3 more definitions. I told you that these definitions, although have not been asked in the examination, still are a little important. So now I'll tell you why I discussed those definitions over there, because you have a reference to that definition over here in section 19. We discussed the relevant market, and we had 2 components of the relevant market, the geographical market and the, remember, the product market. Yes. So let us revise the definition once more, and then we'll see how does it determine what is the geographical market and what is the product market, right? The first definition is the definition of relevant market, which is actually no definition, because the definition itself says that the relevant market will be determined with reference to the geographical market and the product market. So what we actually need to see is what is a geographical market and what is a product market, right? So basically, when we refer to the geographical market, right, we are talking about geographical market basically is an area, a specific area where the demand and the supply of the goods and services are homogeneous, and they can be distinguished from the other market, the area surrounding them, right? So there is, consider a big area, right? And from that big area, the big area is divided into 4 parts, and all 4 parts individually have homogeneous demand and supply. Then in that case, we would not consider that big part to be a geographical market. We would consider those small segments to be geographical market within which the demand and supply is homogeneous. And if the demand and supply of 2 of that 4 area is also homogeneous among themselves, then the 2 areas clubbed would be one geographical area, geographical market, right? You understand what I mean to say by that? So now we would read out the definition that is given to you, right? So the definition says, relevant geographic market means a market comprising the area in which the condition of competition for supply of goods or provision of service or demand of goods or service are distinctly homogeneous and can be distinguished from the conditions prevailing in the neighboring area. That is exactly what I have just explained to you, right? The next definition that we need to see is the relevant product market. So as we have seen in the relevant geographical market, that we deal with the homogeneous concept of the demand and supply in a particular area, right? And when we are talking about the product market, the relevant product market, we are talking about that market or that place where goods, that specific good or similar substitutable goods are being bought and sold, right? So that would be the market. So if you're talking about the market of the cell phone, we are talking about those market where the other cell phones and the similar devices are being sold. It is not a geographical market that you have in your city. Let us go to this market, let us go to that market. No, that market is heterogeneous. It has all the available commodities in the market. You go for buying clothes, you go for buying food, you go for buying your groceries, you go for buying your sports items, you go for everything, right? But now when we are talking about a market referring to a product, we are talking about the market in which the product deals, right? So based on either your geographical market or your product market, you would decide your relevant market, right? So now we know what is a relevant geographical market by the definition, by the meaning. Now how will the commission determine under its inquiry the relevant geographical market for a product or for the enterprise, right? So what are the factors that it would consider? So it would basically see the regulatory and the trade barriers, right? That regulatory and the trade barrier would be different for different region, for different places, different states, right? So if we are talking about a particular geographical market, then that market should have a constant regulatory barriers or trade barriers, right? Then the local specification requirement, that has to be constant throughout that area, right? And then we will also see the national procurement policy, the policy of the nation, the national procurement policy of how do we procure the resources, how do we procure the goods that we need to distribute, right? We would also consider that. We will also consider the adequate distribution facility. That this is not to determine basically the geographical market. This is basically to determine whether or not it is a market. Because if it is a market, it has to have an adequate distribution facility, right? Then it would also depend on the cost. That means if there is a product X and you have to send it at two places, and place A would require 50 rupees for the transport and place B would require 250 rupees for the transport, then this cost itself shows that these two places are distinct. They are differently located. One is very close and one is very far, right? So these two are different geographical market, right? And now you know that if you're talking about a geographical market, there has to be a common language in that area. The language of Bengal is different from the language of Bihar. It is different from the language of UP, different from the Maharashtrian language, different from the Odia language, right? So the geographical area in India, basically, because this is an act of India, would also depend on the language. If you go outside India, you may have a constant language throughout the country, but in India you know that the language is very diversified. So even language becomes the dominant factor to determine the geographical market, specifically in India, right? Then we can also see the consumer preference. Like if you go to Bengal, for the sweets you have the Bengali Rasgulla, very famous, right? If you go to Delhi, you have Chole Bhature, very famous. I'm talking about the food items that you can connect to. If you go to South, dosa, idli, sambar vada is very famous. So you can understand that yes, these things are region specific, right? So that is also to be considered. The consumer's preference needs to be considered, right? And it would also consider the area, the specific area, the diameter, right, within which you can have a secure and regular supply and the rapid after sale services. That is, if you're selling your car in a particular area, then you should have a regular supply in that area. You should not be waiting for 6 months, 7 months because the car is not reaching that area. No, if it is a geographical market for that product, that means you have sale, you have supply, you have distribution. Because we know in geographical market, as per the definition, we have homogeneous demand and supply, right? That means there has to be supplies, right? So these are basically the 8 factors that we would consider for geographical market: the trade barriers, the local requirements, national procurement policy, distribution facility, transport costs, language, consumer preference, and finally the sales, right? Then when we deal with the relevant product market, now when we talk about product and we say that like products or complementary, supplementary products, not complementary, supplementary products, so they are very easily distinguished. When we talk about laptops, mobiles, tablets, right, or the new concept phablet that is coming up, so these have a physical characteristic, a common characteristic. They have their screen. For smartphones, they have the LCD screen where you access through your finger. You have bar phone, you have slide phones, you have flip phones, right? All these have a common characteristic that you can dial numbers, you can make calls, you can have other applications on them, right? And then the price of goods and services. For smartphones, they range from 5,000 to 50,000. Bar phones range from 1,000 to 2,000, 3,000, right? So that is the specification for them. Right? Then you also see the consumer preference. So yeah, the consumers are buying cell phones. Everybody needs a cell phone these days, right? So that is the market. Why you need to see the consumer preference? Because you have to have a market for that. You have to have demand for that product, right? Then exclusion of the in-house production or existence of a specialized producer. This means that you are not producing the stuff in-house. Okay, I'm producing it, I'm selling it, this is my product, my area. Then there is a rare possibility of having a competitive market, like common goods, similar goods, right? Because if you want to have similar good in the market, they have to be supplied from one location, right? So there should be a specialized producer for that good, right? And then you should also be able to classify the industrial products, right? So these are the 6 conditions that would help you to identify the relevant product market, right? But out of these, this is the end of section 19, but out of these, the basic question that you have been asked is one that we have already referred to, right? Explain the factors considered by the commission to ascertain whether the company enjoys a dominant position or not, right? And the other question that this has been asked in your exam twice, right? One is in CA final May 2011, which is not very far back, and again in November 2008, right? And you have been asked question on the appreciable adverse effect of competition as well, section 19 subsection 3, that has been asked in May 2010. So in that question, basically you had been given a situation where 2 companies have entered into an anti-competitive agreement that is having an adverse effect, and someone has sent a notice or an information to the commission to set up an inquiry. Now the question asks you what are the various things that the commission would consider to check, right? So these are basically 2 specific points that you need to understand in this section, and you need to actually learn them up, because you may get a question from that. If you're getting any question from here, you may get a question on section 19 subsection 3 and 19 subsection 4, right? So that will be all for the day. Until next class, this is Abhinay Gupta signing off. Thank you. Bye bye.